program, and it is based upon the number of participants, and that the 2.2 million that you spoke of should be covered by those administrative dollars, and they're not exactly sure how many of the ABODs would participate, even though it were mandated. In their estimation, they were thinking about 9%. Again, I would just caution that in 2020, all work-related requirements and time limits were suspended. So none of those are currently existing.
Senator from Wyandotte, Senator Petty.
Thank you. I would encourage the body to not be thinking about 2020 because we are in 2022, and but I will say that in 2018, the Farm Bill, and SNAP is under the Farm Bill, there were changes made to SNAP, and they required the state to provide supervised job search. And so if we had done something prior to November of 21, it would be different than doing it now, because this then is a change in our program, which means we would have to apply for a waiver in order to make the changes to the program, and those new costs would not be borne by the feds, they would be borne by the state. So those new costs would be incurred by us, not by the federal government. The amount of money that we're getting now, about $73,000 from the feds for this program, is not going to change. That's what we're getting currently, and that's not going to change. But what is going to change is that this then says it's mandatory for all ABOBs, even those who are working. So we're creating a situation that can actually affect the employment, even if it's minimal, of able-bodied individuals without dependents, because we're going to mandate that they go through a training program that they don't need. We're not going to have it funded from the feds, and we're going to have to incur the costs. So then we're jeopardizing our SNAP money, because if we don't fund the over $2.5 million new costs because of increasing the number of people that have to go through the program, then we are jeopardizing our federal dollars because we're not meeting the requirements for our SNAP dollars. So it is a vicious circle that we are setting up by these changes in this legislation. We have a program now. It's DCF, as the senator mentioned. DCF has mentioned the program that we have, and it's working, and it's voluntary. And the working poor who are on SNAP, who have a job, they have to be working 20 hours or less, aren't going through it. But those who aren't employed are able to go through it. So I would encourage us not to jeopardize our federal funds and to not create a situation that we will have to fund, or else we will jeopardize those federal funds at the tune of nearly $3 million. Thank you. This is not a good bill.
Further questions for the senator from Johnson? Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. I looked up the definition of the employment and training program under 7 U.S.C. 2015 D1, and it's well described, but it does not include the opportunity for people who are employed, or does not seem to, through the definition, to not be part of a program that's been designed by the state. So can the senator from Johnson explain, I mean, she said employment and training program, but if you're employed, that doesn't mean that you don't have to also participate in that program. Is that not true?
Senator from Johnson, Senator Gossage.
That is not true. If you are employed, and it just gives you other opportunities for you to do additional training to move up in your job.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. So this is not a requirement. The Kansas Department for Children and Families shall assign all individuals subject to the requirements established to an employment and training program as defined in USC 2015 D4.
Senator from Johnson, Senator Gossage.
And then if you go on down to read the provisions of this subparagraph, shall only apply to able-bodied adults age 18 to 49 without dependents.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. So yes, but those are the people that we're talking about. The programs of this subparagraph apply to those people who are most likely to have a job as described, either as a waitress or, a bartender or teaching dance at the Arts Center. And between, work assignments. So those people are the ones who are assigned to this employment and training program. Can they be excused from this if they already have a job?
Senator from Johnson, Senator Gossage.
Yes, because work or work-related activity applies toward the requirement of being in the employment and training program.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. But this says everyone will be assigned to a program meeting those specific definitions, and I'm reading the definitions of what it was. It's supervised job search programs, job search training programs that include job training and support activities, workfare programs operated under Section 2029 of the title, programs designed to improve the employability of household members through actual work experience or training or both. It doesn't say you're excused if you already have a job.
Senator from Johnson, Senator Gossage.
I think excused would not be the notion of this. It's the idea if they said that they can provide additional training to help you get a higher level job. Even work boots, adjustments to your vehicle, transportation. There are lots of different parts of this, and we even said virtual training, etc. But work and work activity applies to meeting this mandate.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. It says subject to the requirements and the training program as defined. I'm looking at that, and it does not mention that work counts.
Senator from Johnson, do you wish to respond?
I'll wait for my close. Thank you.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. I just want to rise in support of this bill. We are talking about 18 to 49-year-olds, able-bodied, without dependents. This is to help get them off the sidelines, get the training they need, the employment skills they need to get them on their feet, put them on a path of success. And what I hear constantly from my constituents is there's a workforce shortage. We need those people to fill those positions. They're out there, they're available. So I don't, as far as losing federal funds, I don't know that a solid economic development strategy is to base it on government programs. What does work is getting those people back to work, helping them contribute by paying taxes and being productive. And by the way, I believe that helping those people get back to work in skilled jobs that are in demand is good for them. It's good for their health. It's good for their well-being outside of the work factor and being able to support yourself and be independent. So providing the means for people to do that who are able-bodied, able to work without children, to me, it's a win-win. And so I rise strongly in support of this. Thank you, Mr. Chair.
Further questions for the carrier of the bill? Senator from Wyandotte, Senator Petty.
Thank you, Mr. Chairman. So could the senator from Johnson, could you provide the federal guidelines for us for ABOBs?
Senator from Johnson, Senator Gossage.
I'm sure I can get those. Or she may already have them.
Senator from Wyandotte, Senator Petty.
Well, it keeps being make a reference to, and the senator from Sedgwick just referenced getting them to work, but the federal guidelines for ABOBs, they must work at least 80 hours a month or participate in an approved job training program in order to receive the SNAP benefits. That's federal law. So by definition, ABOBs are the working poor. We keep leaving out this word working and poor. They're at 130% of the poverty level or below. This bill now says that working poor who may get SNAP for up to 3 months during a 3-year period, because it doesn't have to be consecutive. They might just need it for a month, because remember, that's a waitress that might have just been getting 20 hours, and next week they're going to be, or then 2 weeks later, they're going to get 40. This legislation now says that they have to be in a training program. That's the change. They have to be in a job training program. They are working. This legislation changes what we're doing in Kansas. It's saying you have to be in a training program even though you're working. This kind of hurts my heart in that we, as a body, often talking about compassion, but we're showing very little compassion to the working poor. And considering that everyone in their chosen work field is not going to always be making a lot of money, but that's the skills that they have, that they are maintaining, and they're working. Now we're going to jeopardize that work that they are doing by saying they have to be in a work program in order to potentially be able to get SNAP to help them make it through. 1 in 8 Kansans are food insecure. These able bodies are in that category. So close your eyes, and some of us might think an able-bodied person is someone who just doesn't want to work. But in fact, that's not what they are. An able-bodied person is, the grandma next door who's working at a grocery store but only is getting 15 hours a week. Or the parent who's not the custodial parent. They're not somebody who's just skipping and saying, I think I'll get SNAP for a month. They can only get it for 3 months, and the average is $112 a month. I bet you spent $112 in the last 3 days when you're home on food. So realize this is not a large benefit. It is, if this were excluding those who are working, which is our current program, we wouldn't have a fiscal note if you've looked at the bill explainer from DCF about how much it would cost. Because that now changes it to be mandatory. So that's the flaw in this piece of legislation. DCF has a good program in place right now, and those that are not working may participate in it. And those that are working, they don't have to participate in it. I applaud us for wanting people work, and I want to see these people to be able to continue to work, but when they need that hand up for that short period of time of SNAP benefits, it's available to them. So keep in mind, 1, it has to be approved by the feds. 2, it's going to cost us for staff and for the expansion of the program close to $3 million that we would need to budget in our budget this year. That has not been covered and is not covered in this bill presently. So let's show that grace and compassion and keep what we have, because it is working.
Senator from Sedgwick, Senator Falscadeau.
Thank you, Mr. Chairman. I appreciate the comments just now from the senator from Wyandotte, Senator Pat Petty. And I do have a question for the senator from Johnson, senator who's carrying the bill.
Please continue.
Thank you, Mr. Chairman. So earlier, and I'm not sure if it came from the senator carrying the bill or another senator, but is the age from 18 to 49, is that in the bill? Is it individuals just in a certain age category that would be required to abide by what we're asking in this particular bill?
Senator from Johnson, Senator Gossage.
Yes, I refer you to page 9, lines 12 and 13. The provision of this subparagraph shall only apply to able-bodied adults without dependents age 18 to 49.
Senator from Sedgwick, Senator Falscadeau.
Thank you, Mr. Chairman. And that gentlelady carrying the bill, she and I have served on the child welfare committees, and I know a lot of times we think that it's only related to foster care issues, but you know, it's still under the Department of Children and Family Services. And Mr. Chairman, when we say SNAP, and what we're really speaking of here today is benefits to purchase food. Mr. Chairman, I do know that during COVID in Wichita, that's where I reside, a lot of the aircraft industry individuals, they were laid off. They were out of work. Even some educators during the summer. I ran into so many people that had jobs making $60,000, $80,000 a year, Mr. Chairman, and they had to go and apply for benefits. In Wichita, Kansas, also, we have a great workforce center, Mr. Chairman, and the reports that I get and the community involvement that I have, Mr. Chairman, in my district, I do know that a lot of those individuals, I'll just say it, the director of the Wichita Workforce shared with me that even though they have a good workforce program, their major problem, and I hope everyone's listening, their major problem was transportation. It was transportation. So to get the $12 or $42 that they would get after filling out that huge application to receive the SNAP benefits, and most of them want to work. They want to work, but their problem is transportation. Mr. Chairman. And I hear a lot of chatter, and I can talk really loud because I want people to hear this. I want the individual carrying the bill to hear this. I'm asking the question of those individuals that would be required to participate in the workforce program training, Mr. Chairman, if we're going to give them a bus pass. So if we want them to go to wherever it is to be trained, most of my constituents don't have the driver's licenses in the car, so they need transportation. So I'm asking the question, in this measure, or when in the final version before it gets to the governor's desk, because I don't have a problem with people. I'm working tonight, Mr. Chairman. I am working tonight. I want people to work. I want people to to participate, add to the tax base. So, but if we're gonna tell them they've got to do these things, and we know they can't walk everywhere, and we won't help them reinstate the driver's licenses, we won't help them. Other people's district might be the business people, and they're looking for the, they're looking to employ people. A lot of the people I represent are the ones that need to be employed, but they don't have a driver's license to get to work. And Keith Loing, the director of the Sedgwick County Wichita Workforce Center, has told me personally the major problem. He's training people, but they don't have transportation. So I'm just asking, I wish I would have, I don't know, I'm asking the senator, will we provide them a bus card, a bus pass to get to the training, to get the little food stamps for 3 months?
Senator from Johnson, Senator Gossage.
Thank you, Mr. Chair. Well, thankfully, the employment and training program includes transportation.
Senator from Sedgwick, Senator Faust-Cadeau.
I don't have any more questions. I'll just close with a comment. It's just sad tonight to hear it's all about the money that we'll receive. It's all about the big business people who have the businesses and they want to employ people. And I know it's a misconception that people don't want to work. You know, we talk about pulling yourselves up by your bootstraps, Mr. Chairman. I know people that don't even have the boots. And so my final question, though, is if they're hungry, most people are not going to go ask you for some food stamps, some snaps, unless they are really in dire need of that food. And that's what we're talking about, is simply filling out that application for 3 months. They're not getting benefits. They're just getting food stamps, basically, food, a EBT card, a vision card to buy food. So in that time, when they fill out the application, if they are deemed eligible, so when do they get their benefits and when would they have to start that training? And because we know a lot of people are getting the benefits now because they lost their jobs, and maybe, so I want to know, so they're not going to get a bus pass because that's not in here. They've got to struggle and find their way to work, and they're going to call me and ask me, Senator, I'm applied for these food stamps, but I don't have a way there. Can you drive me there? So I know that's not going to happen, and I'll still be driving them there. But so I don't know if the senator remembers the second question that I asked. Will they get the benefits first, or do they have to do the training first? They need the food for energy to do the training. Thank you, Mr. Chairman.
Senator from Johnson, Senator Gossage.
My understanding is that they will continue with the food stamps while they are continuing or while they're doing the training. I would also mention that the good news is work boots are included, also bus passes if that helps them to get to and from work.
Senator from Sedgwick, Senator Fauci.
Thank you, Mr. Chairman. Thank you, Senator.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. Chair. It's been stated numerous times about the requirement that they must be working. I pulled this up from DCF, and it says, per the Family's First Coronavirus Act of March 2020, DCF suspended ABOD work requirements and the ABOD time limits beginning in April of 2020. It prohibits state agencies from limiting ABOD eligibility for those individuals until the end of the public health emergency. Mr. Chair, we're still in that public health emergency. Those work requirements, those time limits are suspended while we're in a public health emergency. Again, this isn't a gotcha. This is a way to help. Jobs are there. Good paying jobs are there. This is a way to help those individuals get the training, the transportation, what they need to get back into the workforce, and we desperately need them in the workforce. It is a win-win. Thank you, Mr. Chair.
Senator from Wyandotte, Senator Petty.
Thank you, Mr. Chair. This is a question for the Senator from Johnson. It was asked a moment ago about the benefits that a person participating in the work program would get. Do you know currently what's the average amount that's spent per person in these programs, in this program?
Senator from Johnson, Senator Gossage.
The earlier question was regarding how much of a benefit do they receive, and on average it's $135, so I'm not sure the other question that's being asked.
Senator from Wyandotte, Senator Petty.
Thank you. Well, actually, the average SNAP benefit is about $120 a month, but that's not the question I was asking. The question I was asking had to do with in the work program. The question was asked about what kind of benefits and the person would receive, and do you know the average amount of money that's spent per person in the training program that DCF currently has?
Senator from Johnson, Senator Gossage.
It states that the average cost and benefits to persons participating in the SNAP and ET&T program is $33.45 per month.
Senator from Wyandotte, Senator Petty.
Thank you, and that covers things like transportation, clothing, and assistance to enable them to find and maintain a meaningful employment. So that's the person that participates in the program who's not working. But can you share with us what you're saying that a working person would not have to participate in the training program that appears to be, or is mandated in this program as in the new legislation. But could you tell us if in fact you're correct, which I'm not, DCF doesn't seem to believe you are, but I'm going to go along with this thought. How much would that person need to be working a week in order to meet the work requirements under the being able to, if they're working, not have to do the training program?
Senator from Johnson, Senator Gossage.
Again, there are no work-related requirements currently. If we're merely mandating that they participate in the opportunity and the training. So in the bill, it does not state how much of their work. It just states that in the statute of the ENT employment and training, that work and work-related activities apply toward their training requirement. I have not seen any statement as to how much they have to work. And I can't imagine anybody who wouldn't want to take advantage of a training program.
Senator from Wyandotte, Senator Petty.
Thank you. Well, there is a work requirement under the federal guidelines, and you referred to the federal guidelines earlier. So do you know that work requirement?
Senator from Johnson, Senator Gossage.
I do. It's 20 hours, but that again has been suspended since 2020. It is still suspended. There is no work requirement.
Senator from Wyandotte, Senator Petty.
Thank you. That was suspended by the federal government, and that will be coming back online as of June or July. This bill will be going in effect then. So again, I don't know why we're talking about what's been suspended. Suspended to help the working poor, which is a number of things occurred in the last 2 years. Federal funding to help the working poor, to help our schools, to help our local governments, to help our businesses. I haven't heard us criticizing all of them. This is just one more, but this will become under USDA, which put a hold on that work requirement. It will be coming back on as June or July of this year. So that means that the work requirement is in federal law. It hasn't gone away. Is that correct?
Senator from Johnson, Senator Gossage.
It has not gone away. However, unless somebody is a soothsayer, has one of the 8 balls from back in the day, we have no way of knowing that June or July this will go away.
Senator from Wyandotte, Senator Petty.
Well, I'm not going to put on a wizard hat, but I will take the guidance of the feds here, and that's the information that's come down, is that it will be ending as of June or July. But it seems to be not really relevant to what we're doing, because we're putting into legislation, as you have said, something that we say is going to be good for those able-bodieds who are taking advantage of SNAP for no more than 3 months over a 3-year period of time, getting an average benefit of 100, at the max 120, at the average 120 a month. So my question is, you had said 20 hours a week. Is there a minimum? Is 20 hours a week, or is there, if they fall below, then do they, is there another number in there at all?
Senator from Johnson, Senator Gossage.
I'm sorry, could the senator repeat the question?
Senator from Wyandotte, Senator Petty.
Thank you. You mentioned 20 hours a week working, and my question is there a default number if they go below 20 hours a week that they would have to go under the work program?
Senator from Johnson, Senator Gossage.
I don't have that answer in front of me, but I could find it.
Senator from Wyandotte, Senator Petty.
Thank you. If it's less than 15, then they would have to do training. So if they're working 20 hours a week, under the federal guidelines, they do not have to participate in a work training program. But by this legislation on page 9, that is not the language that is there. It says that to an employment and training program shall assign all individuals subject to the requirements established to an employment and training program as defined. So I'm trying to understand how that line of shall assign all individuals does not apply.
Senator from Johnson, Senator Gossage.
Again, all of those rules have been suspended, and have been suspended now for 2 years. And we believe that this program should be reserved for those who truly need it and to try to help people to raise their station in life, have better training. As Senator Faustido said, transportation to a job, work ideas, work boots, clothing. That's what this program is really all about. And to say it's a requirement, it's actually a really good idea.
Senator from Wyandotte, Senator Petty.
Okay, I'm hearing a different answer than I heard 15 minutes ago. So that's the issue here. Earlier, you were saying if they're working, this doesn't pertain to them. And now you're saying even if they're working 20 hours a week, they still have to be they're still subject to the requirements of being under an employment doing an employment and training program.
Senator from Johnson, Senator Gossage.
My answer has not changed, Mr. Chair. Again, if you are working, the work activity applies toward the training program and toward the employment and training program. It's ENT. And so it's more than just training. They individualized and help people to develop the skills to get to a higher level. I'm only saying I can't imagine why anybody would not want to participate in a program that helps them have a bus pass to get to work, gives them training to elevate their level of ability to work at a higher level job.
Senator from Wyandotte, Senator Petty.
Thank you. Well, I know that it's late, and this is an issue that probably many in the body don't want to have to dwell on, because then we have to think about the poor. And I know you are concerned about the poor, but this doesn't seem to recognize it. If a person is working 20 hours a week, they have to be at 130% of the poverty level in order to even be eligible for SNAP. And the majority of the ABOBs that are on SNAP are working. This change in our legislation now says you have to be under a training program, even though DCF currently has a training program that is voluntary, that those who are not working are participating in. And if you're working and we tell you you have to do a training program, that may mean that you're going to lose the job that you have. How is that a benefit to that working poor? Because I'm not an hourly employee, but I will say when I was in college and in college, I was. And working and hourly employees don't always have control of their hours. They might get to work 20 hours this week and not get over 20 hours by their employer for, the next 3 weeks. So they have to eat. They have to have substances, but they have a job. They don't need training. They don't need to be mandated for training. Let's put it that way. This mandates training. We may all think maybe they need a better job, but that may not be what they believe, and they may be happy with what they're doing. So why would we want to inject government overreach into this decision? This is a program that's in place that DCF has, that's voluntary, that is meeting the requirements. And with these changes, one, we're causing working poor, maybe in many cases, not to be able to work and get SNAP for, as I've said more than once, at a maximum of 3 months. I mean, when I became more educated about this, I thought 3 months. I mean, if you're talking about a training program, you're not going to be, get trained for a new job in 3 months. So this is just, this is a way to hold over. And if you had been in public health and welfare, you heard from harvesters saying, hey, there's lots of working poor out there, and there's no way that we can help them more than we already are. You can't depend on food kitchens and these outside sources, because these are volunteer people that are helping to provide these. So this program helps to meet that need for the working poor, to keep them on their feet so they can get back in that job, to be working more than 20 hours a week. I hope that we keep in mind that we want them to be productive citizens, but every productive citizen is not going to always be able to be making enough money. And mandating a program to cause a working poor person to then not be able to work seems to be counterintuitive. It just contradicts what we want to see happen. We have a program that's working. I also want us to keep in mind that we are now incurring up to $3 million increased costs that will not be covered under SNAP and could jeopardize our SNAP benefits. It's not good for our working poor, our ABOBs. It's not beneficial for our state. Please vote no.
Further questions for the senator from Johnson? Seeing none, Senator, you may close.
Thank you, Mr. Chair. I would just say this. To imply that someone doesn't care about the poor by trying to help them get job skills, clothing, work passes, bus pass, transportation, help them to make modifications to their vehicle is unfortunate and rather insulting. While jobs are important, we as policymakers need to look at solutions that truly do help people by not just providing food assistance, but an opportunity to get job training or work supports that help move them from poverty to prosperity. Thank you, Mr. Chair. I move that when the committee rises and reports, it reports Senate Substitute HB or House Bill 2448 favorably for passage.
You've heard the motion to pass Senate Substitute for House Bill 2448 favorably. All those in favor signify by saying aye.
Aye.
Opposed, no. Ayes appear to have it. Ayes do have it. Motion carries. We'll pass over House Bill 2151 and it will retain a place on the calendar. We'll move next to House Bill 2608. The chair recognizes the senator from Johnson, Senator Warren, to explain the bill.
Thank you, Mr. Chair. 2608 addresses a situation that arises because of a Supreme Court decision last fall in October and another in November regarding restitution for crime victims. And the results of the Supreme Court decisions are remedied in the bill. And the bill is brought to us supported by the Attorney General, the Kansas County District Association, a board member, and a collection firm to help victims of crime get restitution. So what happened with the Supreme Court decisions was that the Supreme Court had found that criminal restitution could not be collected on behalf of those who are crime victims as a civil judgment without a civil jury trial. Well, that's a backlog and no way then to collect the criminal restitution for victims of crime. So what the bill does, it allows the court specific authority to collect restitution for the crime victim that has been ordered by the court through allowing collection of restitution with the garnishment procedure, to garnish paychecks and to garnish bank accounts. This has been a procedure that has been in place for, I don't recall whether it was 50 years or more, that collection agencies on behalf of crime victims have been collecting criminal restitution through civil garnishment procedure. This bill simply restores to the status quo and clarifies and codifies in statute that that is permissible. The bill comes to us on a vote of 117 in favor, 4 against from the House, and it would help restore 70,000 crime victims in Kansas the ability to seek restitution. There was debate in the Senate Judiciary Committee regarding one particular aspect of the bill on page 15 regarding what the definition of earnings for garnishment is. The debate was about whether earnings means compensation paid or payable for personal services, whether it's denominated as wages, salary, commission, bonus, or otherwise. So the question was, well, can you garnish the wages once they are paid and in the bank account? And the decision of the committee was, well, wages are being garnished because it's either a civil court has ordered that you owe the debt to somebody and your wages can therefore be garnished, or a criminal court has ordered that you owe criminal restitution to the victim of crime. So in either event, the court has ordered that this is a debt that you owe. And one final thing that the bill does is that if you, as a criminal defendant who has been ordered to pay restitution, if you make undisputed payments voluntarily, that if later down the road your judgment were deemed to be, were released for some reason, the payments you have voluntarily made to the crime victim are not subject to refund or recoupment. And with that, Mr. Chair, I will stand for questions.
Questions for the carrier of the bill? Senator from Wyandotte, Senator Haley.
Thank you, Mr. Chair. I appreciate the detail that Senator from Johnson, the chair of the Judiciary, has given to 2608. Wanted to add just a little bit of clarity, and by and large, I do support much of what the bill does. I guess for clarity, if she might add the discussion we had in committee, Mr. Chair, regarding the, I guess the mixture of that which is, which is considered to be wages, which the garnishment can attach to, and for restitution, and distinguishing that from what might be other amounts in a particular account. Let me put it like this by way of example, and we hope certainly that she can do a better job of clarifying for the committee of the whole than was clarified before our Judiciary Committee. Let's say that there is a judgment taken to which this bill would apply, that is to garnish a percentage of a debtor's wages for restitution. But there's direct deposit, say, into another account. Some of us receive our payments, our wages by direct deposit, and it goes into account where there are other amounts that could have been accrued from something other than earnings or wages. Could the Senator from Johnson help us to distinguish how only that portion for collection would be attributed to the wages and not the entirety of what might be in that account, if you're understanding what I'm asking, Mr. Chair?
Senator from Johnson.
Thank you, Mr. Chair. So with the debate in committee and the explanation that committee heard from the proponents, and there was an opponent of the bill on behalf of the Kansas Association of Defense Counsel, was in the House, and then I think in the Senate it was a representative from Legal Services, that it has been the practice of the industry and the courts to go ahead and attach what funds are in the bank account and not just in the paycheck. What often happens in practice, though, you get a garnishment order once every 30 days. You garnish that one particular paycheck before it goes into the bank, and then the debtor often then switches bank accounts. So then we heard from the proponents that you don't know where the bank account ends up being the next time, and you don't have opportunity to further collect on the judgment or the restitution order. We heard testimony that with the bill, that the amount of the bank account that would satisfy the restitution order or the other court order could be attached, whether it were wages or otherwise. And the committee decided to favorably pass out of committee to the Senate as a whole the bill as introduced, because otherwise you would be able to protect a bank account from a duly owed debt, and the crime victim would never receive restitution, would never be paid that, and likewise civil orders could not be collected upon either. For instance, hospitals could not be collecting orders of judgment on debtors, and doctors could not, and things of that nature.
Senator from Wyandotte.
I thank the senator from Johnson for clarifying and for duly explaining accurately what was the dichotomy of the discussion in committee and really what has a small amount of dissent from what is otherwise a decent bill. Mr. Chair, some of us remain concerned that there could be pre-existing assets independent of that to which a garnishment order should be attached, that would indeed find themselves being a part of a judgment or settlement for garnishment where these were, again, pre-existing assets. You will note, or we might note, that some of the opposition came that there's still pending certiorari before the Supreme Court and the Arnett case, and that some of these issues might be more clearly delineated as to how a judgment creditor or that collecting entity, that the bill collector, if you will, and there were several that made representation as proponents for this measure, would be able to proceed and go beyond the actual judgment, which is to only bring a certain percentage of one's wages or whatever it's attached to. Usually it's wages, but usually it would be wages, and to go deeper into the personal assets that have nothing to do with what the actual garnishment or the attachment should, except that it's related, I guess, to the same debtor. Those are concerns that are genuinely expressed. I don't know how to briefly go through the mechanics of how I think each of us might find a level of offense in the procedure being done. I take a certain concern with it because otherwise, why do we have these judgments even come forward if they are not supposed to inure to the income or to a particular source like income when the judgment is rendered, a percentage of which. Another concern, and it's also listed too in the fiscal note, and I don't want us to look like we're overreaching. A certain percentage is retained, Mr. Chair, for these judgments. I think they said 1% of the fees collected, and if all of them were to be collected, which of course will never happen, we'll never get 100% of collections, it would be millions of dollars into our judicial branch. I've been a long advocate of funding our judicial branch, and very much so. They were woefully underfunded. However, I think that truth in judgment, not in sentencing, truth in judgment or recovering assets or recovering assets that are credited back from a debt that has been conferred should be a more honest way for us to fund the judicial branch and other entities of state government, and not to create, especially pending what's happening in the Supreme Court with Arnett, a fictitious manner in which we basically go beyond the original intent. You know, and I just share this with you because I hope we move about honestly. Some people and the way in which they collect, some of the collection firms, the judgment firms, they move pretty aggressively, I think, already. They have means of which attaching to people who have fines or fees. And that's my concern, very much so on behalf of those who may have some other assets that have been placed, again, in their savings or in an account that actually is commingled with a wages and seeing that attachment there. So I do want to express those concerns. I thank again the senator from Johnson, the chair of Judiciary, for outlining it in the way in which she has. I'm probably going to vote for this, but I just do so with a certain level of trepidation that it doesn't exactly smell right. I just guess that's the best thing. I have to hold my nose and support it for the overall good of the cause. Thank you, Mr. Chair, and I thank the senator from Johnson.
Further questions for the carrier of the bill? Seeing none, Senator, you may close.
Thank you, Mr. Chair, and thank you for the remarks from the ranking member of the committee from Wyandotte. And we did have testimony from one of the collection firms who works on behalf of 13 of the largest counties in the state of Kansas on behalf of the courts to collect that restitution for crime victims. And I don't think we heard anything that there was anything particularly aggressive or inappropriate in how they went about doing their business. And I want to add that part of our criminal court system is enforcement of the orders made by the court. Without 2608, there would be no means for crime victims to seek restitution. So it is fundamental, if we are going to operate a criminal court system, that we have to have enforcement of those restitution orders. 2608 provides the means to do that. It is necessary, or like I've said before, those 70,000 current victims of crime who have orders of restitution, they need to be able to seek that. With the question about commingling, it is, again, if it's a criminal restitution judgment, then it needs to be paid. And it's not inappropriate to seek that payment from where it can legally be found. That's what this bill does. And it also allows for civil orders of judgment to be pursued as well. Again, these are legitimate debts that have been determined to be owed by a court of law. And we need enforcement, otherwise our court systems cannot function as intended. So with that, Mr. Chair, I move that when the committee rises and reports, it report House Bill 2608 favorably for passage.
You heard the motion. All those in favor signify by saying aye. Opposed, no. Motion carries. We will now turn our attention to Senate substitute for House Bill 2280. Recognize the senator from Cherokee, Senator Hildebrand, to explain the bill and adopt the committee report.
Thank you, Mr. Chairman. I move that we adopt a committee report.
You heard the motion. All those in favor signify by saying aye. Opposed, no. Motion carries. Please continue.
Thank you, Mr. Chairman. I know that the hour is late and everybody's tired and can't keep their eyes open and can't concentrate very much, and I am on that same boat. We're using the same analogy I used earlier, so I'm sorry, I'm tired. That's the only one I've got, so I'm sticking with it. 2280 is, was originally Senate Bill 381, and this bill was introduced because of the Board of Healing Arts has been doing, investigating doctors for prescribing off-label medication to patients. Just to put that in perspective, 20% of all prescriptions filled are for off-label use. I actually had a couple of doctors in my district that actually got letters that they were going to be, or that they are being investigated, and I actually got to see how they worded it from the Board of Healing Arts. To preface that, though, backing up, off-label prescribing is legal in Kansas. Telemedicine, teledoc is legal in Kansas. But the reason why these doctors were getting these letters and being investigated for, listed on the letter that they received, was for prescribing off-label medicine for COVID and for using teledoc, telemedicine, to prescribe off-label medicine. Well, those are all perfectly legal. And what this bill does is it would protect a physician and a patient to be able to still receive that off-label prescription without threat from the Board of Healing Arts to investigate a physician. It also has a provision in it that for a pharmacist, and this one we had to work a couple of times to get it right for the pharmacist to be on board with it. But essentially the only reason why a pharmacist could deny a prescription or could not deny a prescription for ivermectin, hydroxychloroquine, or something else used prescribed for COVID is if they had actually asked, was this for COVID? And then they said, no, we're not going to prescribe it or fill your prescription because it's for COVID. There's also a bill that was added into this bill, and I apologize, I forgot what that number was, but this would guarantee the religious right to refuse a vaccination for any child in child care or public education. And with that, Mr. Chairman, I will stand for questions.
Questions for the carrier of the bill? Senator from Wyandotte, Senator Petty.
Thank you, Mr. Chairman. Would the senator stand for questions? Senator from Cherokee?
There's no requirement to ask him to stand for questions. You may ask your question.
Thank you. So, Senator, you mentioned several things in this bill, and so I'm going to ask you some questions about different parts of it. One of them you mentioned about the Board of Healing Arts, and you mentioned that they've had, you know, they do investigations. Isn't that part of their responsibilities and duties?
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. Chairman. Absolutely, but they should take that as a responsibility as well. Whenever just for example, if you went to a law enforcement officer and said, officer, that person was doing 24 and a 25-mile-an-hour speed limit, I want you to investigate that. Is that law enforcement officer?
Please address the chair.
Mr. Chairman? Sorry. I'm tired. But anyway, Mr. Chairman, so if they're doing 24 and a 25, and you ask them to investigate that person because they were doing 24 and a 25, the law enforcement officer is going to look at you and say, there's nothing to investigate because they are within the limits. You would expect, if you, in a professional environment, that would be the same thing that would happen. Now, if a physician was overprescribing, sure, that should be investigated. So I hope that answers your question.
Senator from Wyandotte, Senator Petty.
To an extent. You referred to, but these investigations are brought forward by either someone, they can be, who can bring forth a request to the Board of Healing Arts?
Senator from Cherokee?
Anyone?
Senator from Wyandotte?
Thank you. And so we're making reference to this occurring in, from the information I have from the Board of Healing Arts, it says there's only 32 investigations that have been open related to COVID-19. So they currently have 559 of all types and only 32 that are related to COVID-19. So we are passing legislation that in response to an issue that has many health factors related to it. You made reference in your remarks about 2280 concerning pharmacists, and are your remarks saying that the Board of Pharmacy now is supportive of this bill?
Senator from Cherokee?
Thank you, Mr. Chairman. I do not believe I ever mentioned the Board of Pharmacy. I said pharmacists.
Senator from Wyandotte?
Thank you. Okay, so I have hundreds of letters from pharmacists that are not supportive of this bill, and it all has to do with the ability that, the responsibility that they have with the oath that they take to consider the welfare of humanity and relief of suffering is their primary concern. I will apply my knowledge, experience, and skills to the best of my ability to assure optimal outcomes for my patients. I will hold myself and my colleagues to the highest principles of our profession, morals, ethics, and legal conduct. So it seems like so many of these emails that I've received, and I'm sure that many of you have received, are concerning their lack of ability that this bill may cause for them to not be able to make decisions that are in the best health, safety of the person coming with a prescription. Can you share with the body how does this bill take away their professional responsibilities?
Senator from Cherokee?
Mr. Chairman, I would love to answer that. What they're referring to, if everybody would recall in my opening statement, that we did have some issues with the pharmacy part and the language of it. That was why this bill was kicked back to fix that. So originally I would agree that there was some concern there and it was valid. We fixed that in committee when we reworded it to say that they could still use their professional judgment. The only reason why they would have to fill a prescription would be if they asked that patient, is this for COVID? And then they said, I'm not going to fill it because it's for COVID.
Senator from Wyandotte?
So can you share with the body where it says that the pharmacist is going to ask if it's COVID and then they say it's not COVID?
Senator from Cherokee?
Thank you, Mr. Chairman. Where it says that refusal to fill or refill such prescription is based solely on a known or assumed diagnosis of COVID infection or its prophylactic treatment. So, understanding the process of getting a prescription filled, if I am the patient and I go to my doctor and I say, I'm having these symptoms, and he gives me a checkup or checks things out and says, yes, Mr. Hildebrand, you have COVID. You're early. what do you think about ivermectin or hydroxychloroquine? And he had that discussion with me, and I said, yeah, doctor, let's try that because I don't want to end up in the hospital. He him or her gives me that prescription. I go to get it filled. When I hand that prescription over to the pharmacist, there's nothing on that prescription that says that's for COVID. It just gives the medicine or whatever the drug is and whatever the dosage and usage is. The pharmacist at that time would either have to assume or ask what that was for. That is the only way a pharmacist would know what that prescription was filled or used for. Thank you, Mr. Chairman. I hope that answered your question.
Senator from Wyandotte.
Well, actually, you didn't say what part of the bill this is in.
Senator from Cherokee.
My apologies, Mr. Chairman. I read from the bill and I should have given you the page and the section. You can find that on page 7, lines 39 through 41.
Senator from Wyandotte.
Thank you. Refusal to fill or refill such prescription is based solely on a known or assumed diagnosis of a COVID-19 infection as its prophylactic treatment. That's the language. So what if a patient demands a lethal dose of a drug that's not listed here and says it's for COVID prevention? Would this bill provide protection for doses known to be lethal of drugs that aren't listed in KSA 21-5705, but are demanded by the patient?
Senator from Cherokee.
Thank you, Mr. Chairman. I'm a little bit perplexed by that question because I'm not sure how a patient could demand that prescription. If a doctor gives a prescription to a patient and it is over the dosage that would be harmful to that patient, and that patient takes it to the pharmacist to have it filled, and that pharmacist practicing their good judgment and faith on that and the well-being of their patient notices that, they can deny filling that prescription. Usually what happens, that pharmacist will get on the phone with the doctor and say, doctor, do you realize that you over prescribed this medication? This is why. And then they come to a conclusion and the doctor can say, oh, yeah, that was a mistake or whatever, and they fix it. That's normally how that would transpire.
Senator from Wyandotte.
Thank you. But the bill says refusal to fill or refill such prescription is based solely on a known or assumed diagnosis of a COVID-19 infection. If the patient that I just mentioned comes with a prescription from the doctor and the pharmacist sees that it's a lethal dose of a drug and is unwilling, but the patient says it's for COVID, how is that not, how is this pharmacist then not, how are they protected under this legislation?
Senator from Cherokee.
Thank you for that question, Mr. Chairman. I would direct your attention to page 7, line 40. The key word in this is solely for the purpose of COVID. So if it is a prescription that is too strong and it's for COVID, that is not solely because of COVID, because clearly there's more than one reason. There's that second reason, that is because it's too much, the prescription is too powerful of a dose. Mr. Chairman, I hope that answered your question.
Senator from Wyandotte.
Thank you. Again, we're moving into some gray area here of determination of who's going to decide on solely, assuming that it's not for COVID. And I think that's why we continue to have so many pharmacists that feel that this is violating their professional responsibility to provide for the best care of patients. I'm going to move on to the other section, or the other bill that was put into this bill, or vice versa, I can't remember now which came first. But dealing with vaccinations, and I would ask the chair, what can school districts do now in relation to immunizations?
Senator from Cherokee.
Mr. Chairman, that question was very broad, and I'm not quite sure where you're getting with that question, but if you could restate it, I'd be more than happy to answer it.
Senator from Wyandotte.
Thank you. What do we currently have in statute dealing with vaccinations?
Senator from Cherokee.
Mr. Chairman, I will attempt to guess where this question was meant to go. I believe the question is referring to the religious exemption that is currently in state statute. So if that, I hope that is the right question that was being asked.
Senator from Wyandotte.
Thank you for that answer. You're correct, that is in state statute under 72-6262. Is there any other exemption under state statute besides religious exemption?
Senator from Cherokee.
Thank you, Mr. Chairman. There is medical.
Senator from Wyandotte.
So thank you for that answer. So this is in statute currently, and yet we have a bill. How does this bill then change the current statute when it comes to daycares, public schools, as far as immunizations?
Senator from Cherokee.
Thank you, Mr. Chairman. Theoretically, it should not, because religious exemption is already in there. But as we have found out during this COVID process, that many places had decided that they were going to give a litmus test on a person's religious belief, and they were going to be the ones to decide whether or not your religion was good enough or not. So what this bill does, it clarifies that no one will give you a litmus test if you put it down as a religious exemption.
Senator from Wyandotte.
So you're saying that the language that's currently that's now in this legislation does not change what is currently in statute?
Senator from Cherokee.
Thank you, Mr. Chairman. It does not change that you can still have a religious exemption or a medical exemption for a prescription. It just clarifies that if you put down a religious exemption, nobody has the right to question your religion.
Senator from Wyandotte.
And is that the language that says, would this currently, in the legislation that we have now, isn't there an expansion of the definition of religious beliefs?
Senator from Cherokee.
Thank you, Mr. Chairman. There is a definition that defines what a religious belief would be.
Senator from Wyandotte.
Well, this legislation, as it's currently written, causes a great deal of concern, not only on my part, but on any of our institutions that deal with children, whether daycare or public or private schools. We have in current law, as the Senator from Cherokee said, we have a written statement signed by one parent or guardian that the child is adhering to the religious denomination whose religious teachings are opposed to such tests or inoculations. We have that. We have that an annual written statement signed by a licensed physician stating the physician's condition, the physical condition of the child to be such that the tests of inoculation would seriously endanger the life or health of the child. But now we're changing this and saying it's due to, I don't understand what. I don't understand the fact that we have this. Schools don't have the time to be spending on interrogating parents when they bring them to school. And the fact that, that we are saying that someone, somewhere, possibly in Kansas, but maybe not, was asked to provide some other verification is a reason for us to actually challenge our having immunizations at all required for children coming into schools. These vaccinations are so important for the health and safety of our children in our schools, and I hope that we would want to keep in mind that no child in Kansas is expendable. And the language that's been put into this legislation will harm the most vulnerable children in our own communities: cancer patients, organ transplant recipients, kids with MS or cystic fibrosis, and so many others. Immunizations protect these children from added health hardships that could kill or disable them. They also protect every other healthy child that's in that school, as well as the adults that are working there. This is vaccinations. Over 90% of Kansas have said that they support vaccinations, and yet we want to jeopardize that healthy responsibility by changing the language that we have in this bill. I encourage the body to keep in mind that vaccinations are for the safety of all of us. We're talking about measles, mumps, diphtheria. I could go on with that list. But we're not just talking about one thing. Pertussin, polio, rubella, tetanus. All of these have a schedule. You probably had your own children vaccinated along the schedule for their safety and for that of in the environments that they were going to be in, whether it was daycare, childcare, whether it was going to camp. This bill speaks to that very area as well. So all of those institutions now are being threatened on what they can ask or what they can expect of those families as they participate in their programs. And they're putting, right now, they're looking out for the safety of the children that are going to participate, whether they're in a preschool, whether they're in maybe you've signed up, maybe your grandchildren or children, you're signing up for a summer program. You're expecting that to be a safe environment, and all of those applications always have on there, are you current on your immunizations? That's for their safety and for the safety of the others that participate. This bill was dealing with one issue that has been blown up, and now we've added in, again, the attack on immunizations and the safety and protection they provide for all of us. I'm sorry that we as a legislature think that that's going to help our families, because it's not. This is a poor piece of legislation, and I hate to see again that we have, this is one more piece that we're attacking, whether our children should be immunized in our schools.
Further questions for the carrier of the bill? Senator from Shawnee, Senator O'Shea.
Thank you, Mr. Chair. The section that was just being referred to, that was it was a bill that was introduced in committee, that was added to this. Did that have an opportunity to have a hearing?
Senator from Cherokee.
Mr. Chairman, no.
Do you think that it would have been good if that one could have had a hearing?
Senator from Shawnee, Senator O'Shea.
I bet. Do you think that one would have been good if it could have had a hearing?
Senator from Cherokee.
Thank you, Mr. Chairman. And I understand where the good senator from Shawnee is going, but we've all been around the block a couple of times in this chamber, and we also understand that not every amendment, not everything that gets put on a bill has a hearing. We are here right now debating what is in this bill. Do I think it's good if everything had a hearing? Yes, I do. But that's not the process that we go by every day in this, under this dome. So until we put a moratorium on no amendments without a hearing, I think we're kind of going down a rabbit trail that has no ending.
Senator from Shawnee, Senator O'Shea.
Thank you, Mr. Chair. I think it's disappointing that it hasn't had a hearing, especially considering the far-reaching impact. Thank you.
Further questions for the carrier of the bill? Senator from Johnson, Senator Holscher.
Thank you, Mr. Chair. Excuse me. Been a long day, and it's been a long time since we actually started working this particular bill, and it's changed and morphed a few times. So I just want to make sure that I am clear on where it stands now with some of the changes that have happened. I believe there are basically two parts: a vaccine exemption, and then the mandating of filling of prescriptions that are for medicines relative to COVID. Is that correct?
Senator from Cherokee.
Mr. Chairman, 2 out of 3 is not bad. But there are 3 parts. The first part is the right for a physician to be able to prescribe off-label.
Senator from Johnson, Senator Holscher.
Thank you. And if I remember correctly, that part was the right to prescribe. That was probably a part of the very original bill. That seems like it was like 10 years ago. But that was part of the original bill, I believe. Is that correct?
Senator from Cherokee.
Thank you, Mr. Chairman. The original bill in 381 that was 10 years ago had actually the first 2 parts, which were the right to prescribe and the pharmacy part.
Senator from Johnson.
Can you tell me what is different about the vaccine exemption in this bill as far as the particular change?
Senator from Cherokee.
Mr. Chairman, I am not 100% sure what the question is. I think we talked about what is in there on the vaccine part, where it was amended in. So if the good senator from Johnson would clarify what part she's asking about, I would appreciate it.
Senator from Johnson.
Is this a religious exemption or a philosophical exemption?
Senator from Cherokee.
Religious exemption is already in there. This just defines what a religious exemption is.
Senator from Johnson.
Can you tell me which religions have policies? I don't know if policy is the right word, but what are the religions that oppose vaccines? And we're talking even the childhood vaccines, mumps, measles, polio.
Senator from Cherokee.
Thank you, Mr. Chairman. I am not an expert on various religions, and I would not have that answer for her.
Senator from Johnson.
Great, thank you. This bill has a lot of concerns. It's one that has concerned me since the first day we had the informational hearing that changed into a bill hearing. Yes, there are 3 parts to it as far as the writing of prescriptions, the vaccine exemption, and the mandating of filling of the prescriptions. A couple things of note. Physicians can already write prescriptions for off-label medications, and it happens all the time, and pharmacists can fill those, and that happens. Where we get into a little bit of a different area, though, is the mandating, because under this bill, pharmacists would have to fill prescriptions for any medications relative to COVID. that takes away some of the discipline of the practice of a pharmaceutical individual, as well as the backing of the industry and the job that they do. But we get into another issue with the vaccine exemption. There are 3 religions that have vaccine opposition. Those are Muslim, Dutch Reform, and Scientology. This, as far as the language in this bill, actually expands the exemption to a philosophical objection. Through that philosophical exemption, what we end up with is a situation where we start to unravel the critical work that's been done in eradicating diseases like polio, hepatitis, measles, mumps, rubella. The bigger issue here is this is not what the people of Kansas want. In a very recent survey, 95% of parents indicated that they are good with and support childhood vaccines. This bill is taking us in a very different direction away from what Kansans want. Again, this part of the bill hasn't had a hearing. Would have been beneficial to be able to really dive into the information and really take a closer look at some of the issues here. And I understand there's been a lot of frustration with living through a pandemic and decisions made during a pandemic. I joked the other day, this was my first pandemic, as it was for everybody. And honestly, it's time for us to move forward without unraveling the proven scientific methods for disease control that have been in place. So I will not be supporting this bill, and I strongly encourage the body not to support it. Thank you.
Further questions for the senator from Cherokee? Senator from Johnson, Senator Thompson.
Thank you, Mr. Chair. Not so much a question as just a comment. What Kansans want is enshrined in our Constitution, Section 7 of the Bill of Rights, covering religious liberty, and this small clause says it all. Nor shall any control of or interference with the rights of conscience be permitted. I have family members who are not members of any of the discussed religions from the previous speaker, and yet they don't agree with vaccine mandates. They don't want their children to be vaccinated. And with regard to whether or not a pharmacist has all sorts of discretion on various prescriptions, I might add that there are numerous off-label FDA-approved drugs used for various reasons. And we could go down that rabbit hole if you want to. There's a blood pressure medicine that's prescribed off-label for all sorts of different things. One of those being Viagra for all sorts of unmentionable things there. But the problem being, we're not going out on a limb here to do something that's out of the ordinary. These are 2 very well-known and established medicines. Doctors have been attempting to prescribe these to help people with early treatment rather than let patients devolve into near-death situations. And I personally know people who've had to sneak some of these medications into hospitals to help people survive. They work, they are useful, and all this bill is doing is attempting to allow our doctors to do their jobs, our patients to make those kind of decisions on their own health care. And with that, I just strongly support this entire bill. Thank you, Mr. Chair.
Further questions? Further questions for the senator from Cherokee, Senator from Johnson, Senator Gossage.
Thank you, Mr. Chair. I know the hour is late. I just wanted to read an excerpt from one of the nearly 400 proponent testimonies we received. This is from a pharmacist. She says, in my 45 years of practicing pharmacy, I've never seen a pharmacist refuse to fill a doctor's prescription for an FDA-approved drug for an off-label use. It's shocking to me that a pharmacist can now tell a physician they can't order a medication for COVID, but that is what is happening. Thank you.
Further questions for the Senator from Cherokee, Senator from Wyandotte, Senator Petty.
Thank you. My question has to deal with, I hear reference to off-label drugs, but could the senator expound on, is this bill only deal with off-label drugs?
Senator from Cherokee.
Thank you, Mr. Chairman. It does deal with off-label drugs when it's written for COVID.
Senator from Wyandotte.
So on page 7, section that you referred me to earlier, or that the senator referred me to earlier, that deals only with off-label drugs.
Senator from Cherokee.
On this part, it would not be off-label, it'd be for any drug for COVID-19, but you do not have, kind of back up just a little bit, we're kind of going down another rabbit hole, which we seem to do quite frequently. There is no danger of a pharmacist not filling a drug unless it's off-label. For COVID, if it's a COVID treatment and it is approved, then they have no reason to refuse it, except for if it is a over prescription, the dosage is too high, or there's an allergic reaction.
Senator from Wyandotte.
Thank you. Well, I just wanted to have clarification. This bill doesn't just deal with off-label drugs. This bill and its limitations on our pharmacists deals with all drugs if, as it says, refusal to fill or refill such prescription is based solely on a known or assumed diagnosis of a COVID-19 infection. So that could be any drug. That doesn't have to be an off-label drug. So we're not just referring to off-label drugs here, although I do believe that this bill was proposed for that very reason. And as the senator from Shawnee brought up earlier about, and I think by the senator from Johnson as well, of having put into this bill a bill that had never had a hearing dealing with the vaccinations, makes it even more of a lethal bill. I will be voting no.
Further questions? Senator from Johnson, Senator Holscher.
Thank you, Mr. Chair. There were a couple points I just want to mention. Excuse me. It was mentioned earlier that there were close to 400 pieces of testimony in favor of the bill. Interestingly, the way, again, that this hearing transpired, it changed from an informational hearing into a bill hearing. And so there really wasn't a lot of time for physicians, pharmacists, other individuals to get testimony in that time period. Plus, we were at the peak surge of the Omicron variant of COVID. So a lot of our healthcare professionals were very, very busy at that time in our hospitals and the like. I will mention to you, though, within 3 days of the hearing, this is the testimony that I received in opposition. And that was just in the initial, that was just to the initial bill, before the part about vaccines were added in. Once that part got added in, I could bring you in probably 5 more stacks like this of opposition. This is a very concerning bill in that regard. Additionally, one thing that's been mentioned, the Board of Healing Arts, they have made it clear, again, physicians can write the prescription, and pharmacists can fill it. Any complaints that have come in have not been in regard to either of those activities. That has to make you wonder what the complaints have been about. Again, lots and lots of issues with this bill. I just strongly encourage the body not to support it.
Further questions for the carrier of the bill? Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I would dispute the comments from the last senator in the sense that I didn't print them out, but I have thousands of emails. I store them in a folder for the vaccine, against the vaccine, all the different parameters that we've seen during COVID. And believe me, Kansans want to have a choice. In this gallery today, we have a doctor who has been challenged for prescribing ivermectin. His license is being challenged. That should not be the case in the state of Kansas. Where I live, the newspaper ran an article giving directions on how to take horse medicine because we couldn't get it from the doctors, or individuals could not get it from the doctors. This should not be the case in Kansas or in the United States. I stand in strong support of this legislation. It's needed, it's past time. Let's move on and get it done for all of Kansas.
Further questions or comments on the bill? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. It's always interesting when we go through floor debates and everything, and sometimes it's obvious that the talking points were written off of an old bill and they didn't update them onto the new bill, which is unfortunate, but I understand how talking points work. One of the things I would like to point out are a couple of things. It was mentioned that there were 52 pending cases with the Board of Healing Arts, but only 39 were due to COVID or prescribing ivermectin. That's more than half. That's a pretty big percentage. To say only, and to say that it wasn't for prescribing or for telemedicine is not accurate as well. I have not seen all 39, but I have seen a few, and they all use that reference. You heard some pretty scary words, that this bill threatens schools. I didn't see anything in here that threatened anything. There's nothing in here that threatens anybody. Attack? We're attacking people in this bill. We did not have a hearing on the bill that puts in the vaccination status. But people in Kansas felt threatened. They felt attacked. And we had a special session because of that. And off of that special session, there were some bills that were written that used this exact same language. They had hearings. That passed this body without any arguments or questions about that like we did tonight. There were some on the other side that did question it as far as how far it goes, but to question that we've never had this in this Senate chamber or had any hearings, yes, not on this bill. No, we did have it in other bills. You also heard, depending on who talked, that 90% on a survey or 95% on a survey of parents are support vaccination of their kids. I think that's great. You know, this bill is not about anti-vaccination. There's nothing in here that says it's anti-vaccination. It does guarantee your religious right. And also, we also heard from one of the speakers that we do know at least of 3 religions that do oppose vaccinations. So are we going to ask everybody that says they have a religious, want a religious exemption, what religion they are, then go look, do a Google search to see if they qualify? I don't think that's what we want to do. Going back to the 90% or 95%, I just went to the CDC site and looked up percentages because you've heard, oh no, we're going to have people not get vaccinated. This body needs to understand that not 100% of people are vaccinated. Not 100% of the kids in school are vaccinated. Just to read you a couple of numbers, there was some tetanus was mentioned. 80.7%. Polio, something I'm well aware of. My mom had polio when she was a kid. I know what the effects of that are. But do you know only 92.6% are vaccinated? Measles, mumps, and rubella. Oh no, we're going to bring that back because we're not going to ask somebody what their religious view is. 90.8%. 9.2% of kids are not vaccinated. Do we have a measles, mumps, rubella outbreak? No. Then there's influenza, 79.6. I'm not quite sure why that is called a vaccine any more than I am COVID's a vaccine. It's a shot. You have to take it annually. Hepatitis B, 90.6%. Chickenpox, 90.2%. And I'm going to really butcher this, so I apologize, but pneumococcal conjugate vaccine, 81%. And then you have the combined 7 vaccine series, 68.3%. I read those numbers just to let the body know and to remind you, not 100% of every person that you walk by is vaccinated. And this is not going to attack, threaten anybody. Mr. Chairman, I move that when the committee rises and report, it report favorably Senate Substitute House Bill 2280 favorably for passage.
You've heard the motion to report Senate Substitute for House Bill 2280 favorably. All those in favor signify by saying aye. Aye. Opposed, no. Ayes appear to have it. Division's been requested. All those in favor, please stand. All those opposed, please stand. Nineteen having voted in favor and 18 against, the motion carries. We'll now turn our attention to House Bill 2541. To explain the bill, the chair recognizes the senator from Sherman, Senator Billinger.
Thank you, Mr. Chairman. House Bill 2541 deals with transferring fees to State General Fund and replacing the fees with SGF. Last session, the legislature appropriated $7.4 million to replace the pandemic loss fee revenue, which was needed to keep the courts in operation. This bill would shift the deposit of the court user fees that fund the core judicial branch operations from court system accounts to the State General Fund. The judicial branch core operates operations would be funded by state general fund budgets. The judicial branch collects approximately $29.4 million each fiscal year for fees that are credited to the judicial branch docket fee fund, the electronic filing and management fund, and the judicial branch non-judicial salary adjustment fund. Currently, state general fund is funding 80% of the budget. So with this change, it would allow the state general fund to receive the fee funds, which generally in years, normal years where we don't have the pandemic, are more than what the required amount is to operate these fee funds. So some years it may fall a little short, and we would have the extra fees from prior years to take care of it. It keeps the judicial system operating on an even keel where they don't have to freeze hiring or something else at a particular time. And with that, I stand for questions.
Questions on House Bill 2541? Senator from Riley, Senator Hawk.
Thank you, Mr. Chairman. I rise in support. This does support our judicial branch. It provides them stability. As the chair just said in his remarks, it's largely a wash. Those fees will go into the general fund, but it does provide them the right accounting move to give them the stability that they need, and I think it's a really good idea.
Further questions for the carrier? Does the senator from Sedgwick wish to be recognized? No? Okay. Further questions? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I move when the committee rises and reports, it reports House Bill 2541 favorably for passage.
You've heard the motion. All those in favor signify by saying aye. Opposed, no. Motion carries. We'll now turn our attention now to Senate substitute for House Bill 2416. The chair recognizes Senator Warren to explain the bill.
Thank you, Mr. Chair. We had started taking a look at this bill yesterday, I think it was. And to remind the body what Senate substitute for House Bill 2416 does, it would require that if a business is used for a contagious disease and used by government action, meaning an order, resolution, or ordinance related to a contagious or infectious disease, and that order or resolution is issued by a governmental entity, then if you, the business, are commandeered, restricted for use, or otherwise used pursuant to that governmental action, you may then file a claim in district court for the compensation for the use, restriction on use, damage, loss, or destruction of your property. And the court shall determine the validity of such claim in the same manner and same procedures described for condemnation actions that are currently in statute. And with that, then, I have an amendment before I would stand for questions.
Yeah, let's go with that amendment number.
The amendment is number 3908.
We'll ask to have that passed out. Do you wish to explain the amendment or have it read?
Yes, Mr. Chair, thank you. The amendment is pretty simple, and it simply strikes on page 1 of the bill everything in line 10 down to line 22. So it strikes new section 1, and then it renumbers the following sections accordingly. By doing so, it doesn't change any of what the bill does. Section 1A, actually it strikes Section 1A, which is lines 10 through 22, and Section 1A is merely kind of prefatory, so it doesn't do more than explain kind of what the bill is all about. With that, I'll stand for questions.
Questions on the amendment? Senator from Leavenworth, Senator Pittman.
Just a point of clarification from the carrier. The bill we're on now, I just want to confirm that it was split yesterday. We voted on the second part, remove that, and the current version that we're working has that amendment in it. Is that correct, Chairman?
Chair recognizes the senator from Johnson, Senator Warren.
Thank you, Mr. Chair. Let me get clarification for certain from the reviser. Well, Mr. Chair, I was able to confirm, not with the reviser, but by other conference and looking at my notes, Section 2 was taken out of the bill when the question was divided when we addressed this yesterday.
Senator from Leavenworth, Senator Pittman.
Thank you. Thank you. I just wanted to confirm that. And this new amendment only affects the Section 1 then that we kept in the bill, correct? Just a point.
Senator from Johnson.
Mr. Chair, yes, that's correct. It only affects Section 1A of the bill.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. So this is the language that says each person within this state shall act and manage the affairs of such person and such person's property in any way that reasonably will assist and not detract from the ability of the state and the public successfully to prevent and respond to contagious or infectious disease. And then some more after that. Is that what we're taking out?
Senator from Johnson.
Mr. Chair, yes, that is part of what we are taking out. We are taking out all of Section 1A. And the reason is that Section 1A, and particularly the part that the senator read, that is prefatory language that was taken from the KEMA statute. And in the KEMA statute, it applies to responding to contagious or infectious disease. Excuse me, it doesn't apply to responding to contagious or infectious disease. What it does apply to in that section is a declared state of disaster emergency. So what the Senate bill that we're looking at, Senate substitute for House Bill 2416, it's not meant in the bill to apply to individuals. And so that Section 1A isn't really part of this bill, because when we're looking at what the bill does, it talks about property being used or commandeered or restricted for use or otherwise used pursuant to governmental action, and not personal action, because the bill also specifically prohibits personal services from being compensated. So it doesn't make sense to leave Section 1A in the bill.
Senator from Douglas.
Thank you, Mr. Chair. I was already concerned about Section 1 because it was only providing this compensation in those cases of contagious events. Does this now apply to all government actions that are described to be compensated, or is it still just related to contagious or infectious disease?
Senator from Johnson.
Thank you, Mr. Chair. The bill itself defines governmental action that it applies to. And that definition is on page 2 of the bill, starting at line 15. Governmental action means an order, resolution, or ordinance related to a contagious or infectious disease issued or adopted by the state county, city, or other political subdivision of the state, including but not limited to an order, resolution, or ordinance, and you can continue to read for yourself there.
Senator from Douglas.
Thank you, Mr. Chair. So I continue to be concerned that this same opportunity is not available in other disasters, and did like the wording that was asking people of the state to step up and do their part.
Further questions for the Senator from Johnson? Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I just want to clarify that when the opportunity comes, I do have an amendment.
Do you have the number?
I do.
Can you share it?
A point of order, Mr. Chair. We're on my...
My apologies. We are on that amendment. Further questions for the carrier of the amendment? Seeing no further questions for the carrier of the amendment, all those in favor signify by saying aye. Opposed, no. Motion carries. Senator from Johnson, do you have another amendment?
Thank you, Mr. Chair. I do not have another amendment.
Senator from Lynn, Senator Tyson.
Thank you. My amendment number is 3891.
Pause for a moment while that's handed out. Would you like to explain the amendment, or would you like to have it read?
I can explain the amendment. Thank you, Mr. Chairman. So last year, this legislation that the chairman just put back in this bill, a majority of that was passed in a Senate tax bill last year. It was brought to me by Representative Corbett that if government shuts down businesses, they shouldn't know property tax. Just makes sense, common sense. Well, while the Senate Tax Committee was working on that piece of legislation, we also worked very diligently on a piece of legislation that would allow businesses that were shut down during COVID-19 to be reimbursed up to $7,500. We would take that money out of COVID funds in order to reimburse those businesses. It didn't compensate for all the loss that those businesses suffered, but it would help under these circumstances. So the amendment is putting back legislation that this Senate body passed last year in a bill and would have been passed in conference committee if it would not have been pulled out the last day of session. With that, I'd stand for questions.
Questions for the carrier of the amendment? Senator from Johnson, Senator Warren.
Thank you, Mr. Chair. And looking for some clarification about the amendment. It was not presented before today or brought to my attention, so I just need some clarification first. The carrier of the amendment first said that it addresses something that the carrier of the bill, me, just put back into the bill. So I'm not sure what that reference is, or maybe I misunderstand, but I didn't, with my amendment, put anything back into the bill.
Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. Didn't she put property tax back in from what was from last night?
Senator from Johnson, Senator Warren.
Thank you, Mr. Chair. No.
Senator from Lynn, Senator Tyson.
Then I withdraw my amendment and I will resubmit it after the property tax piece goes on.
The amendment has been withdrawn. Further questions for the carrier of the bill? Senator from Miami, Senator Baumgartner.
Thank you, Mr. Chair. If I might have a moment, I did just receive my amendment. So if I could get that turned in and
Of course.
then go from there. Thank you.
We'll pause for a moment while the amendment's turned in.
Here's the long version.
Senator from Miami, do you have the amendment number?
I do. Thank you very much, Mr. Chair. It is 3946.
We'll pause for a moment while it's handed out. Senator, would you like the amendment read, or would you prefer to explain it?
Thank you, Mr. Chair. I will explain. So this amendment does several things. First of all, it identifies on page 1, line 14, after disease, that we're talking about diseases in humans. Then what it does is it adds a section 2. And in section 2, when we're talking about disease by inserting in humans, what we are talking about is that if there's any action taken by a county, city, or other political subdivision of the state related to a contiguous, related to a contagious or infectious disease in humans, and then it does make reference to Chapter 65 of the Kansas statutes. It simply says that an owner shall not be eligible for reimbursement if the owner knew or should have known of a dangerous condition and that the owner failed to respond in a reasonable manner to address such dangerous condition. So again, they are not eligible for any type of reimbursement if there was a condition that existed that they did not address, such as shutting down or shutting down to sanitize or address a food safety issue. Mr. Chair, I will stand for any questions.
Questions on the amendment for the senator from Miami? Senator from Leavenworth, Senator Pittman.
Thank you, Mr. Chair. I'm going to challenge germaneness on this.
Germaneness of the amendment has been challenged. The Rules Committee will convene and issue a ruling.
Point of order, Mr. Chair.
Please state your point of order, Senator from Miami.
Is the question of germaneness on 3946 or 3949?
One moment.
I believe it's on the amendment that we just offered, Mr. Chair.
And my question is, what is on the top of that, Mr. Chair?
We're pulling that right now. Give me a moment. $39.49.
Mr. Chair, the amendment that I asked for was 3946. So I'm sorry. I know that, I don't feel like Cinderella, but I think that my carriage turned into a pumpkin. And I think if we were to go back and we were to view the footage, we'd find that I asked for 3946 to be distributed.
One moment. Senator from Miami, this is the amendment that you turned in. We'll see if we can unwind. Hold on.
And Mr. Chair, I turned in 2 amendments.
Mr. Chair.
Senator from Miami, you did not present this amendment 3949, so its distribution is moot. We are on 3946, and we will ask for it to be distributed.
Thank you, Mr. Chair.
3946 will be distributed.
Mr. Chair, if it's important, I can withdraw my challenge until the appropriate time.
The challenge of germaneness on an amendment that was not offered is unnecessary. So, well, this was just distributed in error is where we are at with this particular piece of paper. All right, we have now successfully hit the rewind button. We're on S3946. The carrier of the amendment may explain the amendment.
Thank you, Mr. Chair, and I will explain what I explained before because you guys weren't listening to what I said. Actually, the chamber did not hear what I said about what was on page 2 and 3. So, again, on page 1, we do address the notion that when we're talking about disease, it's disease of humans. And then when we are talking about or if there's any action taken by a county, city, or other political subdivision of the state related to a contagious or infectious disease in humans, and it makes reference to Chapter 46. It does state that an owner shall not be eligible for reimbursement if such owner knew or should have known of a dangerous condition and such owner failed to respond in a reasonable manner to address such dangerous condition that resulted in the shutdown or restriction, including but not limited to sanitization or food safety. I will again stand for questions, Mr. Chair.
Questions for the carrier of the amendment? Senator from Leavenworth, Senator Pittman.
I'd like to, it seems like there is property taxation still inside of this amendment in Section 2. And we removed that yesterday during the process, and therefore it doesn't seem valid as an amendment. It seems like, maybe I'm wrong, but Section 2 is referring to property taxation purposes. So I'd like to challenge the germaneness of this.
It's like deja vu. We have a challenge of the germaneness of the amendment. The Rules Committee will convene and offer a ruling. Chair recognizes the senator from McPherson, Senator Wilborn, with a ruling.
Thank you, Mr. Chair. The Rules Committee unanimously considered this to be germane.
The amendment's ruled germane. We will continue with questions on the amendment for the senator from Miami. Senator from Johnson, Senator Warren.
Thank you, Mr. Chair. And the amendment puts in place a procedure for if your property is commandeered, restricted for use, or otherwise used pursuant to a governmental action. And it talks about how that is going to be done related to property tax, and I find the amendment to be a friendly amendment. Thank you.
Further questions for the carrier of the amendment? Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. So I understand that the senator from Johnson has said that this provides for compensation in those cases. And I agree that it's appropriate. How does this then relate to the opportunity for civil action?
Senator from Miami.
Whoop, Mr. Chair, if I might get some clarification from the senator asking the question. Are you asking about the middle of page 1, the 2, where it says the claimant shall not be eligible, or lower down where it says section 2?
Senator from Douglas.
Lower down where it says section 2.
Senator from Miami.
So if I might, Mr. Chair, the filing is with the Board of County Commissioners that you'll see on the top of page 2. And then it would be up to that reimbursement of property taxes.
Senator
The
from
county treasurer would be handling the reimbursement.
Senator from Douglas.
Thank you, Mr. Chair. So I understand how the amendment works, and that makes sense in terms of the treasurer, but I'm looking back at Part D on page 1, which says any person claiming compensation for the use, restriction on use, damage under this section. So this is still restriction of use. So now we are giving people both the opportunity for civil action and to apply for this compensation.
Senator from Miami.
Mr. Chair, in section 1, you might have that opportunity for civil action, whereas in section 2, you might have that opportunity for property tax relief.
Senator from Douglas.
Thank you, Mr. Chair. Can you do both?
Senator from Miami.
Mr. Chair, there might be that opportunity, but again, that is why we do have that one section in there with regard to property tax relief. You would not be eligible for that if the closure was due to the owner's failure to address an issue. And the issue could be food safety, it could be sanitation, it could be that the facility, let's say it had a balcony, and the last inspection said, boy, these support posts need to be replaced because it looks like there's some wood rot, and they didn't do it. So it collapsed and it was shut down for a period of time.
Senator from Douglas.
Thank you, Mr. Chair, and apologies for not making myself clear. The section 1 of the bill originally allowed for individuals to make a claim if their use of their building was restricted. And this adds the ability, and in fact it says the county treasurer shall reimburse any owner who makes an application determined to be valid for the period of time that the shutdown or restriction remained in effect. And I'm wondering if you can get this property tax relief and also win a civil judgment.
Senator from Miami.
Thank you, Mr. Chair. I believe I already answered that, and the answer was yes.
Senator from Douglas.
Thank you, Mr. Chair. I would be concerned if we are giving property owners 2 forms of reimbursement for the same situation.
Further questions for the Senator from Miami? Senator from Johnson, Senator Warren.
Thank you, Mr. Chair. Just wanted to address that last concern. In section 2, if that were to be adopted, you are making a request for reimbursement of property taxes. That is different than what you would be seeking under section 1 of the bill. You are claiming compensation for the use. So reimbursement for property taxes has different meaning than compensation for the use. So it is not a double recovery of the same damages. We also have in place that in section 1, if you are in district court filing your claim there and pursuing compensation for the reuse, restriction in use, or damage or loss, the court is going to look at also what that award of compensation for the use looks like. For instance, if your balcony was destroyed in your claim that you're seeking, that's different than property tax reimbursement. So the claims are different, but would not be the same recovery for the same use of the property.
Further questions for the senator from Miami? Senator from Douglas, Senator Holland.
Thank you, Mr. Chairman. So I believe the carrier of the amendment is on the tax committee. This language looks familiar to me, the section 2. And maybe this was alluded to before. Is this prior work product out of the tax committee that has now been amended onto this bill?
Senator from Miami.
Thank you, Mr. Chair. This is the work of the reviser.
Senator from Douglas.
Okay, maybe I didn't ask my question enough. Is this language, as I see these fractional amounts, is this basically from, is this policy that came out of basically last year or the year prior when the committee was dealing with basically the concerns about what's happening to small business during the initial COVID shutdown? Or is this just something that is unrelated to that work?
Senator from Miami.
Thank you, Mr. Chair. The section 3 on page 2, according to the reviser, that is the language from the current law. And so it's the section 2 above that, which adds that clarity with regard to if in fact there were a situation where the owner failed to respond in a reasonable manner to address a dangerous condition. But with regard to the language directly below that, yes, the reviser did just indicate that that was language that was prepared last year. And as a point of clarification, the bills with regard to this issue that were seen, there were 2 bills, and one of those bills was seen not only by the tax committee briefly, I think we had an informational hearing on it, but then it was moved from the tax committee to the Judiciary Committee, where we had hearings on that as well.
Senator from Douglas.
Okay, and I apologize to the carrier of the amendment. I appreciate the clarification on that. So just so I understand, on then page 3 of the amendment, it strikes section E, the provision shall be applicable on or after January 1st, 2022. Just so I'm not screwing things up here, this would now make, even though on page 2, Mr. Chairman, section 3, as currently in statute, it looks like it would be effective January 1st, 2022. Is this now retroactive?
Senator from Miami.
Thank you, Mr. Chair. So section C on page 3, by striking that, indicates that no, it is not retroactive.
Senator from Douglas.
So just so I understand, Mr. Chairman, on page 3, the striking of paragraph E does not affect the applicability date of the existing language in that paragraph 3 on page 2?
Senator from Miami.
Thank you, Mr. Chair. By striking section C on page 3, that means that this new portion that we are adding is effective moving forward.
Senator from Douglas.
I'm talking about on page 3, the striking of section E, where it says the provision of this shall be applicable on or after January 1st, 2022. I assume that's currently in statute, but how for the provision of this amendment that has been struck. So what I'm wondering is, and I'm sorry, maybe the liar's aid, I'm just incredibly dense on this, but it appears to me that that existing section 3 on page 2 now could be retroactively to be applied prior to January 1st, 2022. Is that correct or not?
Senator from Miami.
Thank you, Mr. Chair. I'm sorry. When I was looking, because of the way it's struck, I think I referred to it as section C. It is actually section E that is struck. And by striking that, it does indicate that the new portion that's been added is only effective moving forward.
Senator from Douglas.
Okay, thank you.
Further questions for the senator from Miami? Seeing none, Senator, you may close on the amendment.
Thank you, Mr. Chair. I move my amendment.
All those in favor signify by saying aye. Opposed, no. Motion carries. We are back on the bill. Further questions for the senator from Johnson? Senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. My amendment was based off of the original bill, and I thought there was going to be a motion to reconsider to put that section back in. Since they did not take that avenue, the revisors are working diligently to remove the last page, which would strike the previous carrier of the amendments bill, and we do not want to do that. We want to hold that harmless. So I would ask that this bill be passed over until the amendment is ready.
We'll pause for a moment to confer. We will pass over Senate substitute for House Bill 2416. We will now return to the order of business, House Bill 2228. The senator from Johnson, Senator Warren, is standing for questions. Seeing none, Senator, you may close.
Thank you, Mr. Chair. House Bill 2228 is an important tool for our Kansas Bureau of Investigation and law enforcement regarding sexual assault, and would ask the body to support it. And with that, I move that when the committee rises and reports, it report House Bill 2228 favorably for passage.
You've heard the motion. All those in favor signify by saying aye.
Aye.
Opposed, no. Motion carries. Body will stand at ease.
It's more bullshit. She's trying to put a property tax piece on here. Like it's going to sweeten it up or something. I don't know what she's thinking.
Senator from Lynn, are you standing to be recognized?
I am, Mr.
You're
Chairman.
recognized.
Thank you. The revisors just told me that it's in the proofers, so as soon as it's proofed, it'll be on its way up.
Thank you, Senator. We'll continue to stand at ease.
Can they go back and, right, I know it's effective, but could they go back and make a claim for prior tax years? Oh, gosh.
A reminder to the body to make sure your microphones are off while we stand at ease. We'll recognize the senator from Lynn, Senator Tyson.
Thank you, Mr. Chairman. I would offer not a conceptual, a handwritten amendment that I've turned in, and the revisers are on their way up. I would describe the amendment as I previously stated. The amendment would allow for businesses that were shut down during COVID to apply for a rebate or refund on their property taxes up to $7,500, and it will not impact the previous amendment that was put on the bill.
The senator has explained her amendment. Are there questions for the carrier of the amendment? Senator from Douglas, Senator Francisco, when she reaches her desk.
Thank you so much, Mr. Chair. So I'm looking on page 9 of the amendment that was distributed. And in section 13, it says each county shall pay to the state an amount equal to 33% of the refund claims paid pursuant to this act for eligible property located in such county. Can the senator from Lynn describe the reasoning behind that?
Senator from Lynn.
Thank you, Mr. Chairman. The reasoning was because the tax committee had decided that property tax is actually collected and benefited by the local governments. So this way, the local government would use some of their COVID money in order to reimburse those businesses.
Senator from Douglas.
Thank you, Mr. Chair. If the counties would use, I'm assuming that this is the same language as was written last year. So would those counties still have that COVID money available?
Senator from Lynn.
Thank you, Mr. Chairman. From what we've been told, and there will be an audit coming out on this in a few months, we hope that there is money. In fact, there was a school that actually posted in a letter in the newspaper asking for ideas of how to spend the money. So yes, I think those funds are absolutely available. You know, this was a hardship on businesses that they did not anticipate. Hundreds of hairdressers, small businesses throughout the state were shut down with no resources to pay their financial obligations.
Committee, it is late, but it is not happy hour at Shenanigans. Let's keep the sidebar conversations to a minimum. Senator from Lynn.
Thank you, Mr. Chairman.
Senator from Douglas, Senator Francisco.
Thank you, Mr. Chair. So when it says that the refund shall be equal, I'm back on page 5, equal to 33% of the COVID-19 qualifying sum, and this is just how the claim is determined, or the refund is determined.
Senator from Lynn.
Thank you, Mr. Chairman. Would she restate her question? And I do have the amendment and we have a number. Thank you.
Would you like to give us the number and we'll have her restate her question?
That would be great. 3950.
We'll hand out 3915 and we'll have the senator restate her question. I'm sorry, 3950. Thank you, 3950. Senator from Douglas, if you'd like to restate your question, please.
Thank you, Mr. Chair. So I'm looking on page 4 and 5, starting at section 3. So that's where we're determining the amount of the refund. And in Part B, this is on page 5B, the amount of the refund shall be equal to 33% of the COVID qualifying sum. Where is that determined?
Senator from Lynn.
I'm sorry, Mr. Chairman. There was...
We'll have you restate that. Senator from Douglas, it's tough to follow. If you could tighten that up.
So the amount of the refund under this act is 33% of the COVID qualifying sum, which I guess is the sum of the COVID ordered shutdown days and the COVID-ordered restricted operation days gross rebate amount calculated pursuant to deed. So I answered my own question by reading through the rest of the amendment and appreciate the senator from Lynn's question or answer.
Further questions for the senator from Lynn on the amendment? Seeing none, Senator, you may close.
Thank you, Mr. Chairman. I would thank the senator from Douglas and the senator from Reno for their diligent work on putting this amendment together last year. And I would ask the body that to stand in support to help those businesses that owe paid property taxes for when they were shut down and their hardship. With that, I move my amendment.
You've heard the motion. All those in favor signify by saying aye. Opposed, no. Motion carries. We are back on the bill. Questions for the senator from Johnson? Seeing none, Senator from Johnson, you may close.
Thank you, Mr. Chair. The bill provides that when businesses or property is commandeered by government, there shall be a recourse. I hope that's not it. And would appreciate the body's support. With that, Mr. Chair, I move that when the committee rise and report, it reports Senate substitute for House Bill 2416 as amended favorably for passage.
You've heard the motion to report Senate substitute for House Bill 2416 as amended. All those in favor signify by saying aye. Opposed, no. Motion carries. Chair recognizes the Majority Leader from Cowley, Senator Alley.
Thank you, Mr. Chair. I move the committee rise and report.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries.
Clerk will read the committee report.
On motion of Senator Alley, the Senate resolved itself into the Committee of the Whole for consideration of bills on the calendar under the heading of General Orders with Senator Clays in the chair. Recommended House Bill 2299, House Bill 2386, Sub-House Bill 2466, House Bill 2377, House Bill 2228, Sub-House Bill 2280 be amended by the adoption of the committee report and the bill be passed as amended. House Bill 2712, Senate Bill 155, House Bill 2608, House Bill 2541 be passed. House Bill 2537 be amended on motion of Senator Warren and the bill be passed as amended. House Bill 2597, House Bill 2448 be amended by the adoption of the committee report recommending a substitute bill and the substitute bill be passed. Senate Bill 489 be amended by the adoption of the committee report be further amended on motion of Senator Thompson and the bill be passed as further amended. Senate Bill 2456 be amended by the adoption of the committee report be further amended on motion of Senator Peck and the bill be passed as further amended. House Bill 2239 be amended by the adoption of the committee report recommending a substitute bill by amended on motion of Senator Tyson, Baumgartner, and Francisco, and the substitute bill be passed as amended. HCR 5014 be adopted. House Bill 2056 be amended by the adoption of the committee report recommending a substitute bill be amended on motion of Senator Hildebrand, and the substitute bill be passed as amended. House Bill 2607 be amended on motion of Senators Warren and Wilborn, and the bill be passed as amended. Sub-House Bill 2416 be amended on motion of Senators Warren, Baumgartner, and Tyson, and the substitute bill be passed as amended. S sub for House Bill 2062, House Bill 2151 be passed over and retain a place on the calendar.
Chair recognizes the senator from Saline, Senator Clays, to adopt the report.
I move adoption of the committee report.
You've heard the motion. All those in favor say aye. Opposed, no. Report's adopted. Chair recognizes the majority leader from Cali, Senator Alley.
Thank you, Mr. President. I move an emergency be declared, the rules suspended, and the following bills be advanced to final action and roll call. House Bill 2299, House Bill 2712, House Bill 2456, House Bill 2537, House Bill 2386, Senate substitute for House Bill 2239, Senate substitute for House Bill 2597, HCR 5014, Senate substitute for House Bill 2056, Senate Bill 489, substitute for House Bill 2466, House Bill 2228, House Bill 2607, House Bill 2377, Senate Bill 155, Senate substitute for House Bill 2448, House Bill 2608, Senate substitute for House Bill 2280, House Bill 2541, and Senate substitute for House Bill 2416.
You've heard the motion. All those in favor say aye. Opposed, no. Motion passes. We're now ready for final action. And as a reminder, body, we have 6 roll calls to move through because we have all the bills from yesterday and today. I'll remind you, and we will hold tight to it, 2 minutes for any explanation. I highly encourage submitting written explanations in lieu of orating yourself. So we've had some leeway as we do this, but this is a late night. I encourage you to submit them as if you will, in writing, but I'm not going to limit you if you need to speak, but you will be limited to your 2 minutes. When you submit, it's 200 words. On this first roll call, we will take the following. The bills on page 4 through 6, Senate Bill 351, Senate Bill 438, Senate Bill 541, Senate Bill 546, Senate Concurrent Resolution 1619, Senate Concurrent Resolution 1620, Senate Concurrent Resolution 1621, and HB 2110. The clerk will read the titles.
Senate Bill 351, an act concerning elections. Senate Bill 438, an act concerning elections. Senate Bill 541, an act concerning governmental action. Senate Bill 546, an act concerning motor vehicles. SCR 1619, a concurrent resolution urging the legislature to adopt the conclusions and recommendations of the 2021 Special Committee on Taxation regarding the fiscal future of Kansas. SCR 1620, a proposition to amend Article 11 of the Constitution of the State of Kansas by adding a new section thereto. SCR 1621, a proposition to amend Section 5 and 15 of Article 3 of the Constitution of the State of Kansas. House Bill 2110, an act concerning insurance.
Clerk will call the roll.
Alley. Baumgartner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Fag, Faust Godot, Francisco, Gossage, Haley,
Senator, can you repeat your vote on, well, just repeat your whole vote. Let me make sure they got you.
Hildebrand, Hawk, Hildebrand, Holland, Holscher, Kirshen, Cluse, Longbein, Masterson, McGinn, Olson, O'Shea,
Can you repeat? I think they missed your last one.
Peck, Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to change their vote? Does any senator wish to explain their vote? Senator from Montgomery, Senator Peck.
Thank you, Mr. Chair. Mr. President, I vote aye on SCR 1620. I understand some legislators don't like the idea of making it more difficult for the Kansas legislature to increase taxes. I, for one, really like the idea of incentivizing the legislature to look at efficiencies in government and government spending before considering tax increases. However, SCR 1620 is not about what the members of the legislature want. It is about allowing Kansans the opportunity to vote on a constitutional amendment that will require a 2/3 majority vote in order to increase taxes on Kansas families and businesses. To put it another way, a yes vote simply says, I trust Kansas voters, while a no vote says, I know what's better for Kansas voters than they do. Sadly, the reduce, raise, et cetera decisions as it relates to taxes in Kansas has created a hesitancy and uncertainty for job creators, which is business and industry, to come to or expand in Kansas. If the legislature will allow voters to vote and voters decide to amend the state constitution, it will provide consistency in our tax code. Certainty of the tax code will be a good thing for all Kansans, including legislators, and more importantly, Kansas families and job creators. Let's do the right thing for Kansas. I vote yes. I would like my word spread on the journal, Mr. President.
So ordered. Senator from Shawnee, Senator O'Shea.
Thank you, Mr. Chair. Can I have a preliminary vote count on Senate Bill 541 and 1620?
541 on my monitor shows 24 aye, 14 no. And 1620 was 25 aye, 14 no. Senator from Finney, Senator Dole.
Thank you, Mr. President. I'd like to change my vote on 438 from no to aye.
So ordered. Further changes. Senator from Johnson, Senator Thompson.
Thank you, Mr. President. With his permission, I'd like to join the remarks of Senator from Montgomery, Senator Peck.
So ordered. Senator from Lynn.
Thank you, Mr. President. Preliminary vote count on 541.
541, 24 to 14. Further changes or explanations. Senator from Johnson, Senator Warren.
Thank you, Mr. Chair. No change or explanation. Could we get a preliminary vote count on 1621?
1621 is 26 in favor, 13 opposed, 1 absent. For the explanation, Chair would like to join the remarks of the Senator from Montgomery. Seeing none, clerk will close the roll, tally the vote. Twenty-nine having voted in favor and 10 against Senate Bill 351, 38 in favor, 1 opposed to Senate Bill 438, 24 in favor, 14 opposed to Senate Bill 541, 24 in favor and 12 against the passage of Senate Bill 546, 32 in favor and 4 against the passage of House Bill 2110, 28 in favor and 11 opposed to SCR 1619. These measures, having received their constitutional majority, are hereby declared passed. Senate Concurrent Resolution 1620, having received 25 in favor and 14 opposed, and Senate Concurrent Resolution 1622, having received 26 in favor and 13 opposed, hereby have not received their constitutional majority and are hereby declared lost. On the second roll call, we will take the following. The bills on page 7 and 8, House Bill 2363, Senate substitute for House Bill 2458, House Bill 2462, House Bill 2476, House Bill 2481, House Bill 2489, House Bill 2490, House Bill 2547, House Bill 2559, Senate substitute for House Bill 2567. Clerk will read the titles.
House Bill 2363, an act concerning the Board of Indigenous Defense Services. S-Sub House Bill 2458, an act concerning driver's licenses. House Bill 2462, an act concerning the Joint Committee on State Tribal Relations. House Bill 2476, an act concerning motor vehicles. House Bill 2481, an act concerning retirement and pensions. House Bill 2489, an act concerning financial institutions. House Bill 2490, an act concerning persons with disabilities. House Bill 2547, an act concerning insurance. House Bill 2559, an act concerning agriculture. S-Sub House Bill 2567, an act concerning education.
Clerk will call the roll.
Alley. Baumgartner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Fag. Faust Godot. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Holscher. Kirshen. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Senator from Douglas, Senator Holland.
I just want to briefly explain, Mr. President, my past votes on 2489 and 2547.
Please proceed.
Thank you, Mr. President. Body, there was an article about 3 days ago in the Kansas City Star talking about the CEO of Beneficient. He also serves or was serving on the board of directors of GWG Holdings. He and other members of the GWG Holdings board have been sued by investors. My concern is that we have a potential, basically bills before us in those two. That's why I voted pass. We have outstanding litigation of the former parent company. Those two boards of companies, they share certain boards of directors. I am concerned there may have been cash from GWG Holdings been passed on to Beneficient. There may be conflicts of interest here that I am not aware of. I do not feel comfortable voting on these bills. I vote pass. Thank you.
Further explanation. Senator from Barton, Senator Straub.
Thank you, Mr. President. I vote no on House Bill 2559. As a supporter of limited government, this additional layer of bureaucracy undermines our Kansas farmers. A voluntary cotton boll weevil monitoring program like the current one that is successfully operating through non-governmental associations better serves our Kansas farmers. Please protect their First Amendment rights and allow our Kansas farmers the freedom to grow their crops without overreaching government mandates. Thank you. And I do wish my words to be spread on the journal, please.
So ordered. Further explanation. Senator from Reno, Senator Steffen.
Thank you. If you'd be so kind, I'd love to join the senator from Barton.
So ordered. Further explanation? Are there changes? Seeing none, the clerk will close the roll, tally the vote. $35 having voted in favor and 3 against the passage of House Bill 2363. 38 in favor and 1 opposed to House Bill 2458. 39 in favor and none opposed to House Bill 2462, 2476, 2481. 37 having voted in favor and none against the passage of House Bill 2489. 39 having voted in favor and none against the passage of House Bill 2490. 36 in favor, 1 opposed to House Bill 2547, 32 in favor, and 6 opposed to House Bill 2559, 39 having voted in favor and none against House Bill 2567. These measures, having received their constitutional majority, are hereby declared passed. On the third roll call, We'll take the bills on page 9 and 10. House Bill 2568, House Bill 2595, House Bill 2605, House Bill 2703, House Concurrent Resolutions 5022, and House Concurrent Resolutions 5030. Clerk will read the titles.
House Bill 2568, an act concerning financial institutions. House Bill 2595, an act concerning motor vehicles. House Bill 2605, an act concerning animal care. House Bill 2703, an act concerning employment security law. HCR 5022, a proposition to amend Section 2 and 5 of Article 9 of the Constitution of the State of Kansas to require that a sheriff be elected in each county for a term of 4 years. HCR 5030, a concurrent resolution recognizing the growing problem of anti-Semitism in the United States and calling for the adoption of the International Holocaust Remembrance Alliance working definition of anti-Semitism as an important tool to address the problem.
Clerk will call the roll.
Alley, Baumgartner, Billinger, Bowers, Clays, Corson, Dietrich, Dahl, Erickson, Fag, Faust-Godot, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Holscher, Kirshen, Clues, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to explain their vote? Senator from Douglas, Senator Francisco.
Thank you, Mr. President. I vote aye on House Bill 2605, the act concerning veterinary training rural program, and report to the body that $378,000 was appropriated in 2021 for the program. Thank you. I do not need my remarks spread on the journal.
Very good. Further explanation? Changes? Seeing none, the clerk will close the roll. Tally the vote. $38 having voted in favor and 1 opposed to House Bill 2568. 39 having voted in favor and none against the passage of House Bill 2595, House Bill 2605, House Bill 2703. 36 having voted in favor and 2 opposed to HCR 5022. 38 having voted in favor and none against HCR 5030. These measures having received their constitutional majority are hereby declared passed. On this fourth roll call, we will take the following. The bills on page 10 and 11, House Bill 2299, House Bill 2712, House Bill 2456, House Bill 2537, House Bill 2386, Senate substitute for House Bill 2239. Clerk will read the titles.
House Bill 2299, an act concerning crimes, punishment, and criminal procedure. House Bill 2712, an act establishing the Kansas Commission for the United States semi-quincentennial as part of the Department of Commerce. House Bill 2456, an act concerning wildlife. House Bill 2537, an act concerning insurance department. House Bill 2386, an act concerning insurance. S sub. House Bill 2239, an act concerning income taxation.
Clerk will call the roll.
Alley. Baumgartner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Fag. Faust-Godot. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Holscher. Kirshen. Clues. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson. Petty. Pittman. Pyle. Reichman. Steffen. Straub. Solentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to explain their vote? And wish to change their vote? Seeing none, the clerk will close the roll, tally the vote. "36 having voted in favor and 2 opposed to House Bill 2239. 39 having voted in favor and none against House Bill 2299, House Bill 2386. 38 having voted in favor and none opposed to House Bill 2456. 39 having voted in favor and none against House Bill 2537 and House Bill 2712. These measures having reached their constitutional majority are hereby declared passed. On this fifth roll call, we will take the following. The bills on page 12 and 13. Senate sub for House Bill 2597, HCR 5014, Senate sub for House Bill 2056, Senate Bill 489, substitute for House Bill 2466, House Bill 2228, House Bill 2607, and House Bill 2377. Clerk will read the titles.
S sub House Bill 2597, an act concerning property taxation. HCR 5014, a proposition to amend Article 1 of the Constitution of the State of Kansas by adding a new section thereto concerning oversight by the legislator of certain executive branch actions, as sub House Bill 2056, an act concerning elections, Senate Bill 489, an act concerning infectious or contagious diseases, sub House Bill 2466, an act concerning education, House Bill 2228, an act concerning sexual assault evidence kits, House Bill 2607, an act concerning civilian actions, House Bill 2377, an act concerning driving.
Clerk will call the roll.
Alley, Baumgartner, Billinger, Bowers,
There is no 2062 on the, we passed over it. You need a repeat of the vote? Could you repeat your vote, please?
Bowers,
Could you please repeat your vote? Thank you.
Clays, Orson, Dietrich, Dahl, Erickson, Fag, Faust Godot, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Holscher, Kirshen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty,
Could you please repeat? Yeah. Thank you.
Pittman, Pyle, Reichman, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to explain their vote? Senator from Reno, Senator Steffen.
Can I get a preliminary count on 489, please?
489 shows 24 in favor, 15 opposed. Senator from Barton, Senator Straub.
Thank you, Mr. President. I vote aye on Senate substitute for House Bill 2056. The American public demands election security, and their confidence in our election procedures and laws is paramount. While this bill doesn't solve every election security issue, it is a good place to start. We still have much to do on auditing our voter rolls. Without voter confidence in our elections, every law the legislature passes can and should be called into question. Secure elections will quite literally determine the future of our state and our nation. Thank you. And I do wish my words to be spread across the journal, please.
So ordered. Senator from Johnson, Senator Holscher.
Thank you, Mr. President. I'd like to offer explanation of vote for HB 2056.
Please proceed.
When I entered the House in 2016, I served alongside Scott Schwab. I will tell you, Representative Schwab and I didn't always align on our votes on major issues. However, he was a rule follower, he worked hard, and he worked ethically. Secretary of State Schwab has indicated repeatedly that our elections are secure and has provided communication along with a vast amount of information in that regard. I have confidence in the job he and his staff have performed and the information he has put forward. It's been mentioned that we want to instill confidence in our elections. The best way to instill confidence is by not giving in to conspiracy theories, and it certainly isn't by building bills on false narratives.
Would you like your remarks spread on the journal? So ordered. Further explanation. Senator from Johnson, Senator Corson.
I'd just like to join Senator Holscher with her permission.
So ordered. Further explanation. Are there changes? Senator from Wyandotte, Senator Haley.
Thank you, Mr. President. I'd like to change my pass on 2466 to a no. Thank you.
So ordered. Further explanation or changes? Senator from Sedgwick, Senator Falsquito.
Thank you, Mr. President. I vote aye on 2377. I believe that we should give people second chances, and we are giving those with a DUI a second chance. Although I wish this body would have given those with a revoked driver's license status just for failure to pay a traffic violation a second chance. Mr. President, I vote aye on House Bill 2377.
Would you like your remarks spread on the journal? Very good. Senator from Johnson, Senator Corson.
I so agreed with the sentiments of my colleague from Johnson, but it has been pointed out to me that I did not serve with Secretary Schwab, so I will not put my name on those statements on her explanation vote. I'm sorry, thank you.
Withdrawn. Further explanation. Any changes? Seeing none, the clerk will close the roll, tally the vote. "24 having voted in favor and 15 opposed the passage of Senate Bill 489, 22 in favor and 17 against House Bill 2056, 39 in favor and none opposed to House Bill 2228, 38 having voted in favor and 1 opposed to House Bill 2377, 27 having voted in favor and 11 opposed to House Bill 2466, 32 having voted in favor and 6 opposed to House Bill 2597, 39 having voted in favor and none opposed to House Bill 2607, 27 having voted in favor and 12 opposed to HCR 5014. These measures having received their constitutional majority are hereby declared passed and adopted. On this sixth roll call, we will take the following. The bills on page 14 through 16, Senate Bill 155, Senate sub for House Bill 2448, House Bill 2608, Senate sub for House Bill 2280, House Bill 2541, and Senate sub for House Bill 2416. Clerk will read the titles.
Senate Bill 155, an act concerning health and healthcare. S sub House Bill 2448, an act concerning public assistance. House Bill 2608, an act concerning judgments. S sub House Bill 2280, an act concerning health and healthcare. House Bill 2541, an act concerning the judicial branch. S sub House Bill 2416, an act concerning public health.
Clerk will call the roll.
Alley. Baumgartner. Billinger. Bowers. Bowers. Oh, I'm sorry. Oh, was that the one I just called? Yeah. Oops. Clays? Corson? Dietrich? Dahl? Erickson, Fag, Faust Godot,
Senator from Sedgwick. Correct, yeah, page 16.
Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Holscher, Kirshen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Had an opportunity to vote. Does any senator wish to explain their vote? Senator from Wyandotte, Senator Petty.
Thank you. Kansas children need our help and protection. Making it harder to mitigate the spread of disease in our schools and child care settings puts kids and people the kids come in contact with at risk. 95% of Kansans believe vaccines are very important to maintaining good health. These vaccines requirements that have been in place since 1979 have served our families and community well. I vote no on SB 22.
Like your
And
marks
I'd like
on the
my
journal.
spread
So
on the
ordered.
journal. Thank you.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. Could we get a preliminary count on 2280?
21 in favor, 16 opposed, the remaining passing or absent.
I apologize. 2280 was what?
21 in favor, 16 opposed.
Thank you.
Senator from Reno, Senator Stephan.
I voted yes on Senate substitute for HB 2280 solely because it has the ability to prevent suffering and death through the promotion of the early treatment of COVID. Thousands of Kansans and hundreds of thousands of Americans have died needlessly because of mainstream medicine, or mainstream and academic medicine's shutdown of effective treatment protocols that utilize FDA-approved medications such as HCQ and ivermectin. This fearful, greedy, political, and incompetent shutdown of early treatment will be deemed a national tragedy in time. Thank you, and please spread them.
So ordered. Senator from Johnson, Senator Sykes.
I would like to join the remarks from the Senator from Wyandotte.
So ordered. Senator from Johnson, Senator Thompson.
With this permission, Mr. President, I'd like to join the remarks from the senator from Reno.
So ordered. Senator from Barton, Senator Straub.
Thank you, Mr. President. With his permission, I'd also like to join the remarks of the Senator from Reno, Senator Stephan, please.
So ordered. Senator from Miami, Senator Baumgartner.
Thank you, Mr. President. Same request from the senator from Reno.
So ordered. Senator from Shawnee, Senator O'Shea.
Thank you. Explanation of vote. The COVID pandemic posed so many new challenges for our families, for our businesses, and for this legislature. In fact, the reason I ran for the Senate was to make sure small businesses like my own were not harmed by the future management of pandemics. But our duty to wisely govern through future pandemics should not be used as a vehicle to undo the proven medical advances that generations before us have invested in. Through careful research and the sacrifices of our parents, grandparents, these medical advances allow children and grandchildren the chance to grow up without knowing the debilitating effects of serious diseases like polio and meningitis. The last-minute amendment that was tacked onto this bill regarding school-aged immunizations is troubling. As a new mother, I cannot support creating blanket exemptions that will take our state backwards and likely allow for them to return to the dangerous diseases that have nearly been eradicated in our country by safe, effective immunizations.
Would you like your remarks spread on the journal? So ordered. Senator from Johnson, Senator Holscher.
Thank you, Mr. President. I vote no for HB 2280. Doctors have always had the ability to write prescriptions for off-label medications, and pharmacists have always been able to fill them. This bill does not change that. Several pieces of testimony received from pharmacists opposing this bill indicated they had received prescriptions for ivermectin for extremely high incorrect dosages. One pharmacist indicated such a script had a dosage 18 times the recommended level. Overdosing on ivermectin can lead to coma and death. This bill is dangerous for another reason. It unravels proven scientific methods for disease control through the expansion of vaccine exemptions. Additionally, this bill requires a pharmacist to dispense any medication prescribed under the guise of COVID, any medication. That body creates a very slippery, concerning slope. Now, with this provision, for consulting with attorneys and doctors, a doctor, and that's me consulting with doctors and attorneys to make sure the interpretation is correct. Now, with this provision, a doctor can write a prescription for an abortion medication under the guise of COVID, and the pharmacist must fill it.
Would you like your remarks spread on the journal? So ordered. Further explanation, Senator from Sedgwick, Senator Faustigo.
Thank you, Mr. President. I want to change my I vote on 2608 to no.
So ordered. Any further changes? Seeing none, the clerk will close the roll, tally the vote.
39 having voted in favor and none opposed to the passage of Senate Bill 155. 21 having voted in favor and 16 opposed to House Bill 2280. 26 having voted in favor and 11 opposed to House Bill 2416. 27 having voted in favor and 12 against House Bill 2448. 34 having voted in favor and 5 opposed to House Bill 2541 and House Bill 2608. These measures having received their constitutional majority are hereby declared passed. Reports of standing committees, the clerk will read.
Mr. President, the Committee on Public Health and Welfare recommends House Bill 2253 be amended and the bill be passed as amended. Senator Hildebrand, chairperson. Mr. President, the Committee on Public Health and Welfare recommends House Bill 2582 be amended and the bill be passed as amended. Senator Hildebrand, chairperson.
Messages from the House, clerk will read.
Announcing passage of Senate Bill 367, announcing passage of Senate Bill 434, Senate Bill 506, Senate Bill 450, announcing adoption of HCR 5035, House Concurrent Resolution 5035, a concurrent resolution relating to the adjournment of the Senate and House of Representatives for a period of time during the 2022 regular session of the Legislature.
This constitutes introduction of HCR 5035. To adopt HCR 5035, Chair recognizes the Majority Leader from Cali, Senator Alley.
Thank you, Mr. Chair. I move the emergency be declared, the rules suspended, and HCR 5035 be adopted by voice vote.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Are there announcements? Seeing none, Chair recognizes the Majority Leader from Cali, Senator Alley.
Thank you, Mr. President. I move the Senate adjourn until 10 a.m. on Monday, March 28, 2022.
You've heard the motion. All those in favor say aye. Opposed, no. Motion carries. Senate's adjourned.